L.B. Sullivan was the public safety commissioner and one of the 3 people in charge of police in Montgomery, Alabama. One day, when he sat down to read the New York Times after a protest broke out at a local college, he noticed that civil rights leaders ran a full-page ad in the New York Times to help raise funds to help the civil rights leaders. The ad described what is called an unprecedented wave of terror of police actions against the peaceful protesters. What it described was mostly accurate, but some of the charges in the ad just weren't true. The ad also contained the false statement, when the entire student body protested to state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission. The ad didn't mention Sullivan's name, but because he was involved with the police, he claimed that the ad implied that he was responsible for the actions of the police. He claimed that the ad damaged his reputation in the community. Sullivan sent a written request to the Times to publicly redact the information, as required for a public figure to seek punitive damages in a libel action under Alabama law. He felt the need to sue for libel when they refused to take down the ad.
Are you all seeing this right now?
In the Alabama court, Sullivan won his case and the New York Times was ordered to pay $500,000 in damages. The New York Times appealed and it went to the Supreme Court. Sullivan had argued that a lot of the information in the ad was wrong and made the citizens view the police negatively. For instance, it alluded to the students marching to the Capitol singing, "My country 'tis of thee," though they in fact sung the Star-Spangled Banner. Moreover, 4 of the ministers listed as sponsors of the ad testified that they had never seen it and that their names had been used without their permission. The newspaper argued that it had no intention of hurting L.B. Sullivan. The newspaper had no reason to believe that the advertisement included false statements, so it did not check their accuracy. The Times argued that if a newspaper had to check the accuracy of every criticism of every public official, free press would be severely limited. They voted unanimously with the New York Times. The court defined what is meant by libel and slander as it pertains to public officials and public figures. Individuals must show false statements were made and publicized with malice or knowledge of them being false, or with reckless disregard of their truth or falsity. This statement makes it very hard for public figures to win libel suits. New York Times versus Sullivan is important because it protects the press and the public's right to criticize public officials in the conduct of their duties. William J. Brennan, Jr. wrote the majority opinion. We hold that the rule of law applied by the Alabama courts is constitutionally deficient, which basically means that the Alabama libel law doesn't have enough involvement with the Constitution. The publication here was not a commercial advertisement. It communicated information, expressed opinion, recited grievances on behalf of a movement of the highest public interest and concern. And that means that the U.S. Supreme Court reject the Alabama Supreme Court's reasoning that because the document in question was printed in the newspaper for a fee, it's commercial advertisement and therefore unprotected by the First Amendment. Debate on public issues should be uninhibited. It may well include vehement attacks on government and public officials. And that means that the necessary commitment of free speech is a commitment also to the public's right to criticize its government. Such criticism is not only acceptable, but also crucial to one's public duty. This decision affected future cases because it's one of the most important cases on American free speech values. To quote Forbes, Time v. Sullivan has had such an impact on just about every free speech and free press case for the past half-century, influencing everything from how we accept debate and tolerate speech we disagree with to our legal definitions of privacy, obscenity, and indecency.